be as simple as just resharing because it should already be up.
Yeah. Hey, Andy, I'm just letting you know that I'm going to stop the share so I can share my QR code thing for the sign in, and then you can restart in a couple of minutes.
Okay.
And nice to meet you. I'm James Fairfax Colombo. I'm assistant professor here at UNM.
Yes, I understand you're also the director of your program too, training program. Yep. Excellent.
Really what that means is I have to do all the admin work.
Yeah, it's okay.
Not as
it's just one of those rites of passage. Well done.
Thank you. So my screen will go dark and then so I'll disappear so that it's just you guys on the screen. But it was great to meet you and see you, and I'm really looking forward to it.
Thank you.
Okay, so I just want folks who are joining us, I can't see what our participants are at right now, but folks who are, we're at 90, who are joining us, the link that I just submitted in the chat and this QR code is for CME sign-in. It's not for the evaluation. The evaluation link in order to access the certificate for your CEUs is submitted in the chat in the last 5 minutes. So if you are interested in accessing the medical education units, you'll want to take a picture of the QR code or look in the chat for the link, and then you can fill it out, and that just logs your attendance for CMEs. And I'll just give it a couple more minutes and make some more announcements and hand it over to Simone.
And then Rachel, did you see Angie, the captioner, is asking for the API token?
Oh, no, because
in the Q&A.
I'm assuming we need our videos on, is that correct?
Yes, because I'm not sure if as long as you're sharing the screen, it should continue to show the PowerPoint, but your video doesn't necessarily need to be on. It's also just a small thumbnail in the corner. The main screen is the PowerPoint.
Okay.
Do
you want the video on?
Sure.
Okay.
It's going to be hard to go through this and notice both the chats and the questions.
Yeah, so nothing comes through the chat. We've disabled the chat. The Q&A is the only thing that people submit questions through, and Simone will be moderating the Q&A.
Okay.
Thank you, Simone. At 67, that kind of multitasking drives me nuts.
Okay, so Andy, why don't you go ahead and pull up your slides?
Okay.
And I'll just start making some announcements. So if, first of all, thanks for joining us, folks. My name is Rachel Hasna. I'm with the University of New Mexico's Division for Community Behavioral Health. Welcome to our Law and Mental Health Didactic Series. The link that you see in the chat is for sign in for CMEs. This is not the evaluation link to access your CEs. This is just the sign in. If you're interested in medical education units, you'll want to click on that link and fill out the information. This logs your attendance. In terms of our CEU process, in order to qualify for CEUs, you need to be present for the entire hour. We will submit a link in the chat in the last 5 minutes of the lecture. Click on that link, fill out the evaluation. A certificate of attendance is automatically generated for you. If you scroll to the bottom right of the certificate, you can email yourself a copy. It's your responsibility to save a copy. We do not mail copies. If you're joining us by phone, you can email us and I'm happy to send you that link. And we will be sharing the recording link as well as the PowerPoint slides by the end of this week or beginning of next week. And if you have any questions, please feel free to submit them in the chat. And I'll hand it over to you, Simone.
Thank you, Rachel. Okay, so welcome to the University of New Mexico Law and Mental Health Didactic Series. So this series is hosted by UNM Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad to have you all join us today. My name is Simone Fullion. I am covering for Julie Brovko today, who is usually the lovely face that you get to see on the screen to do this. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. I help Julie and James, who's also on here, run this didactic series. First, I want to remind you to join us next week. At that time, Dr. Offer Zur will be presenting Truth and Myths, Standards of Care of Psychotherapy, the role of forensic psychologists in mental health licensing board hearings and psychotherapy malpractice lawsuits. So that's what's going to be presented next week. Should be really interesting, so we hope you all join us. Next, for our talk today, as usual, please ask questions in the Q&A anytime that you feel comfortable, but just know that we're only going to get to them at the end. Also, we always try to do our best to get as many of your questions as possible, but please forgive us if we cannot get to yours. For those of you who want CEUs and you're on a tight schedule, you have to stay for the full hour, but you do not have to stay longer than that. So we may go over a few minutes to answer some questions, but if you have to jump off right at the hour, that's fine. Just remember to grab that link and complete the evaluation. So I will try to let you know when the hour has passed, and we will also be posting the CE link at that time, as Rachel mentioned. So speaking of continuing educations, we're so excited to announce that we were approved to offer CMEs, and that's what Rachel was showing the QR code to sign in. We are also working on getting CLEs for attorneys. So we're working on that as we speak. So stay tuned and tell your friends, spread the word. So now what we've all been waiting for today, I'd like to introduce our speakers for the day. We have Dr. Andrew Benjamin and Dr. Kelly Champion. I'm going to introduce them each separately, and then I'm going to hand it off to them to do their magic for us today. So while working with families engaged in high conflict litigation and lawyers suffering from various mental health and drug abuse problems, Dr. Benjamin is named Professor of the Year by the Washington State Bar Association Family Law Section. He was elected to serve as president of Washington State Psychological Association, and later his colleagues created an association award named after him for outstanding and tireless contributions. He was honored by the Puyallup Indian Nation's Health Authority for serving a modern-day warrior fighting the mental illness, drug alcohol addictions of the people served by the nation's program. After being elected representative of Washington to the APA's council for 2 terms, he was appointed the council parliamentarian. I'm so glad I said that correctly because that's a very big word, and served in the capacity during 4 terms. He has served as a member and a chair of the APA's Committee on Legal Issues, the APA's Policy Planning Board member for the APA Board of Educational Affairs, and the inaugural chair of APA's Good Governance Needs Assessments, Slating and Campaigns Committee. So he has served as past president of APA's divisions for states, provinces, and territories. He's a fellow of the American Psychological Association divisions 18, 31, 41, 42, 43, 45, 49, and 55. That's a lot. The APA conferred the Carl F. Heisner Award in recognition of his record of public service and advocacy in numerous areas of professional activity. Also, while serving in the faculty of Department of Psychology and School of Law for the University of Washington, Dr. Benjamin has published 73 peer-reviewed articles in psychology, law, and psychiatry journals. He's also authored 5 books published by APA within the areas of largely child custody, and he also has a lecture series which is posted on YouTube. He lives in Seattle with his wife for 45 years, and he's an ardent feminist, which I love to hear, and has been for more than 50 years. So please welcome Dr. Benjamin. We're so happy to have you here. Next up, Dr. Kelly Champion. She's a clinical child and adolescent psychologist with additional specialty training and experience in responding to violence and trauma, eating disorders, and behavioral medicine across a lifespan. She's completed her undergraduate degree at the University of Michigan and her master's degree at clinical psychology at Eastern Michigan University. Her PhD is from the clinical child and adolescent psychology program at the University of Kansas. She's board certified by the American Board of Professional Psychology in clinical child and adolescent psychology and completed the American Psychological Association Leadership Institute for Women in Psychology in 2012. Currently, she works as a clinical psychologist part-time for the Harvard Vanguard Medical Associates and as an independent clinical and forensic psychologist. She's also the director of operations for the Northeast Regional Training Center of the American Psychological Association Violence Prevention Program. I told them earlier that I was going to try to do this at like an auctioneer speed, but I'm doing my best, guys. I think I'm getting pretty close to the auctioneer speed.
Mom, I gotta stop you because for some reason you have an old bio. Currently, I'm a clinical and forensic psychologist and I live at the edge of DC. I don't have any other roles. I'm writing and publishing on law and psychology and courts. And I take care of children and adults who present with anxiety, depression, trauma. We'll just leave it there.
Okay.
Those are old jobs. Those are old jobs.
Gotcha. Well, there's still achievements and we're still so grateful to have both of you here. So I just want to stop there and say thank you again for coming. And we really appreciate you taking the time and filling out all the paperwork. So thank you so much for being here. I'm going to hand it over to you both.
Thank you. Thank you very much for the introductions. We're going to try to leave 10 to 15 minutes at the end of the presentation for questions. I got into this work back in the 1980s, in large part because it became pretty evident that first, psychologists were really phobic of lawyers and legal process. And second, we really needed more psychologists in this realm of child custody work, both either to conduct evaluations or to engage in the treatment of the parties and their children. And so I developed a program called the Parenting Evaluation Training Program back then. We started collecting lots of qualitative data on the evaluations we were conducting on the parties for the Superior Court of King County mostly, sometimes for Snohomish County and Spokane counties. What we found is that, and it's something that we really wanted to focus on, is party satisfaction. And as we watched those videotape, we improved our protocol. And the result of all those hundreds of hours of reviewing videotape were the publications of two of the books that were mentioned. One on child custody evaluation was published, and the first edition was published in 2003, and the second edition was published by the American Psychological Press again in 2018. So we're going to be touching upon the aspects of the protocol today that keep people from getting licensing board complaints. We also know that inherent in people getting licensing board complaints, one or both of the parties that are being evaluated typically have felt disrespected or violated in some other manner. And so this protocol really is informed by trying to keep the process as transparent as possible. We don't ever surprise the parties in the process that they go through. We make sure that we're respectful to the parties all the way through the process. And we engage in repeated ratifications of each step of the process so that we know that no errors have been committed. I feel pretty comfortable with this process. I've done now, I've kind of lost track, but I think more than 1,000 of these evaluations, and I've never personally gotten a licensing board complaint filed against me. And most of the graduates out of this program also have not gotten licensing board complaints filed against them. As you know, there's some risk for malpractice in these instances as well. And none of my students have ever had a malpractice complaint filed against them, or suit filed against them. I certainly haven't either. So with that, I'm going to turn it over to Dr. Champion. We've been asked to put into the slide deck this slide, this slide, this slide. Dr. Champion.
Good afternoon. So one of the things that we want to start with is, why did we call this trauma informed? And when I met Andy and learned about his process, I said, this one makes sense. This one seems safe. And one of the reasons is it acknowledges this research established fact. First of all, that family violence, harsh conflict are really common stressors. These are reasons people show up in our offices. And we know that in both therapy and research settings, and it's been established, Chopitra did some really interesting work watching what his therapists were doing. Both researchers and therapists don't ask about traumatic events and exposure to violence. And it's been well established that if you don't ask, people do not talk about it. And so we need to make sure that we keep this at the forefront of our minds as scientists and practitioners. The other thing that has been established again and again and again, and in my opinion, often not presented transparently, is that child adjustment to divorce and stressors. So in families with and without separation, child adjustment is predicted from parenting behavior, not the amount of time, but the quality of the parenting behavior. And unfair criticism of a co-parent boomerangs. Emory has shown us that when someone is denigrating, criticizing harshly, children have a profound sense of fairness and they don't like it if you're unfair. So when a parent is unfairly criticizing the other parent, is bringing up events that haven't happened, is blowing events out of proportions, kids don't like it, it's not fair, and it has a negative reflection on the parent who is doing that, not on the other. Coercive family processes was established by Jerry Patterson 40 years ago, more than 40 years ago, as something that is a negative cycle. The parent and the child get trapped in a parent using adverse behavior to control the child reacting with adverse behavior. The result of that is behavior problems in the child. And Russell Barkley has a beautiful flow chart. The end result of that is either the parent or the child or both of them just losing it. And something goes horribly wrong and there's aggression and violence and who knows what. Coercive family processes over time result in one outcome, which is the child resists and refuses parental control and direction, both at home and outside of the home. When we talk today about why do you need to know the allegations of adverse parent behavior, violence, history of violence, don't forget what coercive family processes has been established to result in. I want to briefly talk about intimate partner violence and the fact of coercive control. Kevin Hamburger and his team remind us carefully to think about coercive control as behaviorists. And if you're going to define something as coercive control, which is the key to understanding intimate partner violence, not battering, not physical violence, but the impact of the adverse behavior, is coercive when the result is the other person, the victim of this, is modifying, adjusting, changing their behavior to accommodate, prevent, and reduce the negative behavior by the more powerful partner. So what I want to make sure we keep talking about is when we say intimate partner violence, we are talking about behavior by a more powerful person, the more person who controls through physical size or control of the social resources or control of the financial resources, the rest of the family to get what they want. And it really helps to think about, did it result in accommodating those demands? When there is coercive control and that accommodation, that is a high risk, that predicts problems in parenting. There's a high risk of problems in parenting by the person who's behaving that way. And that has impacts on children since before birth, because the mother, most typically the one we best understand where most of it comes out, it's just a base rates problem. We do see this with female victims, male perpetrators. So the mother carrying those infants is accommodating that, it's creating stress. And so intimate partner violence affects those children from before they get on the planet. And so you can't say it's over, it's done, family separation, nothing to think about. The stress has already happened. After the child's born, those events happen. The child was present. Maybe they weren't in the same room, but they were present for that accommodation. Oftentimes they are in the same room. When a child goes through a negative event early in childhood, while their brain is developing, while they're developing language skills, they are developing memory skills. The child's narrative, the child's report of what happened is developing while the child develops. So when they have these negative events very early in childhood, they need to come back to these narratives. They need to talk to somebody who has an adult memory, adult language skills. The child needs to talk about that. When you get involved in court as a family, there can be interference with that. And the child's brain is developing, their language skills are developing. What they need to do is be able to talk about what happened, to have somebody say, that is what happened. I was there. This is what was there to protect you. And it's important that we try to think about protecting the child's development and being cognizant of their early development and the impact these negative events can have on it.
Thank you, Kelly. So the reason why we went into this detail, this level of detail, is to show you that really truly most of the cases that of high conflict custody cases, have a myriad of different allegations attached to both parties. And it's really important that you kind of keep in mind that generally there's something going on around coercive control issues in most of these cases. And they tend to be the trickier cases to evaluate because a bunch of that behavior is hidden from the world. So our comprehensive parenting evaluations are always court-ordered, or in some instances agreed to by stipulation. For many jurisdictions, if they're court-ordered, there's a qualified immunity attached to the evaluation, an evaluator for malpractice issues. It's helpful. There are always allegation and issued or concern driven. So we want to make sure all those concerns that both parties have about each other are absolutely evaluated by the end of the process. None of the findings that result of this process emerge unless there's multiple measure corroboration based on the facts of the evaluation. And finally, we operationalize any of the parenting behaviors that are of concern, so that those operationalized behaviors can be remediated through the treatment recommendations that generally follow. These are the 6 phases of our protocol, of our evaluation protocol. There is a bunch of detail that we're not going to get into. Instead, I'm just going to focus on each aspect of the phase that I think prompts this sense of fair process, respectful process, transparent process.
I want to step in for a minute because, Andy, you've talked about this. I've read your book. I think that when you look for multiple sources of data to understand the allegations, because violence is a private event, I've heard you talk about your cases. Sometimes these investigations to get the multiple sources are pretty creative. I think too often we see people saying, well, they're just reporting something behind closed doors, we can move on. And I hope that by the end of this, when you see all the different ways that this protocol comes at this question, you will see that there might be more to find out.
Absolutely. And we start then really at the beginning, where even before we see the parties, they're filling out a very, very detailed questionnaire about any possible allegation that could exist. And they're providing detail about each one of those allegations that we then repeatedly check throughout the rest of the phases of the process. We do psychological testing, structured clinical interviews, parent-child observations, and collateral documentation. Every aspect of this process is standardized. We do it the same way, each evaluation after evaluation.
The details
Yep, please, Kelly, go ahead.
Yeah, the details of allegations matter a lot. You need to understand, if you haven't spent a lot of time talking about the different roles people have in responding to domestic violence and child abuse, then you don't know that these investigators tend not to investigate. They tend to go by reports. They don't take pictures. They don't look for corroboration. You, as the evaluator, may be the only person that attempts to corroborate this. And we don't have time to go into all the creative ways that you can, but you cannot count on someone else having done that the way you might think with a crime.
So part of how we ratify this process is we videotape all client contact. And we comb through the videotape to make sure that we're accurately reporting what's been said or what has actually happened if we're looking at observations of parents and children. We get all the fees up front. Flat fees seem to lead to people feeling less aggrieved about the process. So if they know what they're going to be charged, and they're charged one fee for the evaluation process and one fee for deposition and trial, they feel more comfortable with the fee policy. We let them know that there are no such things as confidentiality. There's no such thing as confidentiality in this process. Everything will be eventually available to the lawyers, if they're lawyers in the case, certainly to the other party, if the party is a pro se litigant. We make sure that even prior to the party starting this process, we give a complete description of the process, including more than 30 steps of the evaluation process that are articulated in writing so that the parties are not surprised by any step of the process. And of course, we explain the videotaping process. And we also let them know that honestly, the children's interest will always come first. We never have ex parte contact with any of the lawyers or judge in the case. Never, ever, never, ever. And so that means when the lawyers call, they go into voicemail. We sent an email out to the lawyer that's called. We copy the other lawyer on that email. And we respond in writing to all lawyer contact. We also try to do that with the parties once they've begun the process and are in the midst of the process, so that nobody feels like someone is talking out of school without there being a record of what's being said. Of course, we do record those emails, and we hold those emails as part of the documentation. We don't ever proceed to the next phase of the evaluation process until both parties have completed the phase they're in. And sometimes, particularly in phase one, the pre-evaluation procedures, perhaps even phase two, one of the parties might stall out. If that happens, we give full fair notice to the lawyers in the case and to both of the parties that we'll have to send out a declaration of noncompliance or an affidavit of noncompliance, depending upon the jurisdiction. And we just report the facts of what has happened that has led to the party not completing that phase. In that way, the clerk of the court can inform the judge that it's not the evaluator's fault that the evaluation's bombed out. This is a joke that you don't have in your deck, in your materials, but under the fair use doctrine, I thought it would be appropriate to put it in. It says I put them up after divorce, so he knows his father is still part of his life.
You know, this is really funny when we look at it, but something to keep in mind when we talk about pushing positive relationships between co-parents. There are parents out there that are hostile, that are aggressive, that are seeking control. And you're literally asking the other parent to do this. So you need to be paying attention. How does this person think about their right to power and control over family members? And if it's with this kind of hostility, that is harmful to children.
So phase two, these are the steps that we think lead to phase two feeling fair to the parties that go through the testing and clinical interview process. As Emery et al. Said, psychological testing in high conflict cases, custody cases, has questionable validity and reliability. Even though this is an old finding, I think it's still true. And I would recommend that anybody who engages in this work use psychological testing to generate hypotheses. We're really strong adherents of the hypothesis process of conducting evaluation. We want to minimize our clinical judgment errors by making sure that we're contemporaneously writing up what the parties have said, double checking the videotape to make sure we haven't misunderstood any aspect of what the party has said, and being sure that the parties have another opportunity to flesh out each of their allegations. We actually provide them a form and model the level of detail we expect. We pick out the worst of the allegations and we model for them in the structured interview process, the level of detail that we expect from them, and we send them home with those forms to send back after phase two is completed.
This is an important step to make sure that you literally take a step back. And when you have allegations from both sides, a lot of times it's going to fit a certain narrative and a certain set of assumptions that you have. And the implicit bias that we bring to interpreting the data that comes to us is real. And we're terrible at checking it. And so when you get all of those allegations, independent of the testing, it's important to think about, hey, does this fit some assumption that I came in with? And what does it look like if I flip it around? And that's why when you give both parties the opportunity to make each of their allegations clearly, you have a chance to try to step into another set of shoes.
Absolutely. And you know, we were trying to prove the null hypothesis here, but that means you got to understand that the validity of our clinical judgments have really been called into question. Garb's done some fabulous research on this. These are the clinical judgment errors that are pretty apparent in most child custody evaluations. And we try to minimize them as much as possible through this, trying to use the null hypothesis standard, trying to make sure that we don't arrive at any finding unless there's multiple measure corroboration.
And I want to come back to what I started with, which is that people are not going to report being harmed or being exposed to trauma unless you ask. They don't. And if somebody's over-reporting and that's your experience, there's one hypothesis to test, which is no one's ever asked or no one's listening. Instead of they're just trying to convince me, and if they keep saying it, it's because it's not true. Well, that might be your bias, or that might be a fact. You need to sort that out.
Absolutely. And so before we conduct the parent-child observations, we've let the parties know at the end of the clinical interview when they're going to be scheduled. We give them both an oral and written instruction. And this is really important because if people are overwhelmed as they go through this evaluation process. And so as much as possible, we try to prompt them with written detail to make sure that they have a chance to look at what has been said after the fact and double check their memories based upon written instructions. And so the written instruction for parent-child observation says, come prepared to play for an hour. Come prepared to play for an hour. Or if it's with teens, come prepared to talk with your teen for an hour. You know, that's what the written instruction says. And we let them know that the child will go first in child-directed play or conversation. The adult will go second in parent-directed play or conversation. And there'll be a kind of a cleanup period for the younger children. Now, also before we get to parent-child observations, both parties will have received their psychosocial section of the evaluation that's been written up. And also the write-up of the party's allegations about the other party. And we ask people to get back to us anything that they think should be changed. This is that ratification process that we've talked about. We want people, again, to feel fairly treated. We want them to know how we've recorded their information. And if they have differences of opinion, great, we're going to put them in so that the reader of our report can see that there was a difference of opinion about what was said during the clinical interview. Kelly, you had something to say?
Well, I think you went through that so fast that you had to know what you were saying, Andy, to catch it, which is that you've actually written your psychosocial up and you have now sent it to the person who gave you that information. And they get an opportunity to say to you, you didn't hear me correctly. Or while I was talking, I forgot to tell you. And we're not used to doing that. We should do that. Then it's transparent. It takes nerve and commitment. I'm not going to say it's not. Now, I don't know if you were going to keep going with this slide, Andy, because there were some other things. Or
no, that's good. Go carry on.
So parent-child observations. Some of you have been trained in clinical child and adolescent psychology.
Oh, hang on. Good point. Here we go. So this is the next cartoon. Thank you, Adrian. Parenting is a learning process and your criticisms help. Now go, Kelly.
Well, you were doing child observations.
Yes, ma'am.
Yeah. Oh, okay. Sorry, we were a little smoother before. If you haven't been trained in doing parent-child therapy by a behaviorist and you think, I don't know how to code compliance, non-compliance, inappropriate behavior, indirect questions, what are those? What am I asking people to do? What's labeled behavioral praise? What's unlabeled praise? Why does it matter? It does matter. You can learn how to do it. You can actually, if you do a really good internet search, you can find somebody put the coding right up there. Or you can go get training from the PCIT people, parent-child interaction therapy. You can go get Carolyn Schroeder's book, and she describes how to code parent-child interactions with young children. That will give you a way of comparing the parents and give you some behaviors to look for, to see, is the parent able to be responsive? How do I code this?
And because both parents will have their parent-child observations recorded, video recorded, that's so helpful because you can go through those recordings back to back and compare the standardized part of the process and how each of these parties are responding to that process. And some of the damnedest material comes emerging out of the process, particularly for younger children, that really show pretty clearly what they think about their parents.
I mean, you can see kids that don't have any idea what to do. You can see parents that have no words for these kids. At the same time, I've also watched parents in therapy settings be so like the parents actually gradually shaping the kid to more and more violent play, and really that's how they interact. That's not a great sign. Not a great sign.
So at the end of that process, we actually inquire to the party that's been observed, was this a fair representation of your play? If it was the play session, talk, if it was talk. And if the parent says, no, something went wrong, we find out what went wrong, and then we give them another appointment. Now, of course, we have to engage parallel process. So even though the other party may not have complained about their parent-child observation, we'll do round 2 for them as well. We schedule the last appointment. That's that closing interview, that phase 5 of our process that I think is still pretty difficult for psychologists to engage in, but we strongly recommend that feedback session occur. We schedule that last appointment before parties walk out. We let the videotape run as people exit the room because in particular, small kids say the damnedest thing on the way out. It's just so many interesting comments are made. We observe how they exit the office. At this point, we have more than enough data to write up our initial findings of this evaluation process and really test our hypotheses to date. We operationalize the behaviors that are going to affect or have affected the current parenting, the future parenting, and we're making sure that we're building that report so that the legal factors of the jurisdiction that the psychologist operating in, that psychological evidence is organized under those legal factors in the discussion section of the report. If there's some limiting factors to parenting, such as a parent needs supervised visitation if they've engaged in domestic violence or sexual abuse or alcohol and drug abuse, we'll be discussing the evidence under those limiting factors as well.
Can you go back, Andy?
Sure.
It's really important to take what looks like boilerplate stuff on this slide a lot more serious than it looks. Because in your code of ethics, if you're a psychologist doing this work, you're responsible for how the lawyers, the judge, the court, the GAL, the parents understand the way that you have brought your testing and your observational science into the courtroom. You are responsible for how they take that technical language and what interpretations you made and how it translates. Ethically, psychologists are responsible for this. So you need to be thinking about, when you lay out the allegations, when you lay out the potential factors, the unsubstantiated factors, what the science says about what those factors likely predict. You're responsible for what people walk away with. And that is a lot more important than a boilerplate slide makes it look like.
Absolutely. And this is about, again, this notion of therapeutic jurisprudence. If we're going to move these highly litigious parties into settlement mode, and that in most instances would be in the best interest of the children that whose families we're evaluating, because it leads to less money being spent on the lawyers involved in these cases, which we hope will be used to help the kids in these cases. Nevertheless, we want the settlement discussions to occur. And so our credibility as experts will be judged by how we're able to explain the psychology of these cases. And if the psychology is organized under the legal factors, it makes a lot more sense to my sisters and brothers in the law. So when we build the discussion section, we're also preparing questions for particular collaterals. We're deciding which firsthand witnesses we need to see. If in fact there are firsthand witnesses that are not professional witnesses, we're asking the party who has given us up that firsthand witness to go get a declaration from that firsthand witness about what they actually observed, because we want to see that declaration be sworn under the laws of perjury before we interview a non-professional. As non-professionals, particularly in this part of the forensic world, do change their stories pretty quickly. And so that fixes in one point in time what that non-professional collateral might say. We also want to make sure that we're thinking about which of the collaterals we might want to hold to the very end of the process because we're worried about a party getting to a collateral and attempting to unduly influence a particular collateral. So again, findings are only made if there are admissions or multiple measure corroboration. This is the standard of practice for these particular kinds of custody cases. Collateral information. These are the points that are really important that we want to make sure are structured and we engage in. I mentioned this earlier, that we hold off some people until the very end of the process to interview, typically before that influential party is going through the closing interview, so that they don't have an opportunity to unduly influence the collateral we want to talk with.
So this is actually sort of the other side of sending your psychosocial to your reporter. Now you're talking to the party and you're saying, here was this allegation. Here's what the testing showed. Here's what I observed. Here's what this other person in an affidavit alleged to have seen you do or had you done. So this all supports my concern about this allegation. You're actually, you know, Andy skipped right over it, but you're kind of setting up a situation where you're more likely to get admissions to weaknesses, problems that needed to be addressed.
Correct. And so this is what's noteworthy coming out of our collateral interviews. If we don't have evidence emerging from collaterals along these lines, you know, that's something that we'll pay attention to and we'll write up very directly in the discussion section. When we engage in all of our interviews, either with parties or with collaterals, we really stick with reflective listening. We want to make sure that during the reflective listening, we're seeking clarification, we're actually accurately reflecting back what a party has said, and we're summarizing what a party has said. We're giving them more opportunity to expand on what is being said by engaging in just basic reflective listening skills. So these are the most important aspects of this last second to last phase, phase 5, where we're doing closing interviews of the parties. We do this in large part because we want to make sure that each party has an opportunity to contest what we find. And we want to make sure that any evidence that emerges is bearing on this question of parenting and what can possibly affect parenting. During this closing interview, we're going to first clarify any factual inconsistencies that have remained, and then we move right into talking about each finding. We start with the worst finding first, and we lay out each piece of damning evidence. And we give the party a chance to respond to each piece of damning evidence. And this is where, as Dr. Champion said, we'll get admissions. Because as we go through damning fact after damning fact, it tends to pierce denial and minimization. And so about 40% of the cases that we're evaluating will get admissions. Now, admissions are important just because of cognitive dissonance. You're going to have people being more willing to change if they admit to their behaviors. So it's a really important aspect of this protocol. And they're going to be less likely to file a licensing board complaint, we think, because they have an opportunity to disagree with you in person. So we actually urge people to think about how you can use videotape in vivo, particularly parent-child observation tape sometimes can be shown. And for instance, a really great example of somebody who's engaged in domestic violence is when, you know, they're playing with their child and the kid gives a clear-cut startle response, you know, as the parent reaches across the kid for a toy or something. So it's that kind of thing that will be more likely to show in a closing interview with a party. But again, it's just one of those damning details of many details that will lead to a finding.
This is a place too where I'm going to encourage you to make sure that you've got your knowledge of development. I specifically recall in training watching a parent-child observation for the purpose of doing parent-child interaction therapy. And the mom wasn't doing anything wrong. When she said it's time to clean up, this little guy under 5 flipped over the table, came at the mom with a string of obscenities. That child learned that behavior, observed that behavior, saw that interaction somewhere else. And it's important that you be sensitive to how do children react to exposure to violence? How does that change their behavior? What does that look like?
Thank you. And so as we talk with the parties, we recite all the facts that have emerged. We generally challenge any inconsistencies or discrepancies, but we do that in a respectful way. We won't fight with people. We just agree to disagree if a party strongly contests that something we found is wrong. That's fine. We do give them an opportunity to send us any written information subsequent to the closing interview. We give them 72 hours, 48 hours to 72 hours to get us more declarations, anything they want to prove that our finding is wrong.
Don't forget to be mindful of your own safety. We do know that men with high risk of coercive control, intimate partner violence, domestic violence are emotional and reactive, especially or only when confronted with wrongdoing or real threats. If they're in danger of losing their power and you are the reason, I am not going to schedule a late evening meeting in an empty office building without doing something attentive to my own safety.
I totally agree. And we found that this is another reason why videotape helps. For whatever reason, you know, thousands of cases later, any of my graduates who use this protocol and any of the cases I've supervised or done myself have never led to anybody violently acting out. And I think it has to do, again, with the transparency, the respectful tone we always set, but also the videotape. I think it helps. So the last phase of the evaluation process is just preparing for the lawyers. This is what's essential. We always meet with the lawyers. We do that in large part to encourage settlement. If they see you and you, before you send out the evaluation report and you lay out the concerns that the parties raised and what the findings were about those concerns, then hand the report, have them go to the recommendation section, they will be woefully unprepared, which is a good thing, but they will ask good questions to test your credibility, which is a good thing. And they're going to be more likely than to go away and start talking about settlement. And that, I think, highlights this notion again of therapeutic jurisprudence.
And we haven't kept coming back to it, but this entire thing is organized on the children's well-being, on establishing the safest, secure, nurturing home and the most amount of time in that environment. And you need to explain how your scientific data is moving the child in that direction.
And so this is just the standard way we approach any talk with any lawyer under any circumstances. I don't have to tell you all about it. So with that, we have about 11 minutes for questions. Dr. Champion and I would take any question that the audience has.
Great, thank you so much. So we have some questions. I'm going to start working my way down them. So the first question we have is, how do you define more powerful partner? Obviously, power can be physical, emotional, etc.
Kelly, please take that.
So all of it counts. People can use physical power, physical threats. They can use financial power. They can use social power. Somebody might be much better prepared to manipulate information, to get control of resources. And you need to be looking at how did it turn out? One of the things that's really difficult to catch is our gender roles. Yeah, it's 2021, but our gender roles are pretty rigid. And we accommodate some of those expectations way too quickly. And people stay in partnership because of those gender roles. And we know that. So you need to step back and say, but is that effective for the child's development? What do we know from research? If mom works full time, the kid actually comes out better, especially the girls, because it's more equitable. So if we're not going to get corroboration of sexual power. If someone alleges a rape, there wasn't anybody there. So we need to look for other evidence that they're manipulative or dishonest. I think we don't always accommodate the power of lying. And I've seen people dismiss lying to a partner without looking at what was the effect of that lie. And did the lie result in him, sorry, it's just easier for me to say it that way. I realize not always, but did that result in him getting something that he might have wanted or getting something over on him?
You're here. And this highlights where generally those lies go, and that is in a form of another power control tactic, which is abusive litigation. That party is going to be more likely to file motion after motion after motion. And in many of these cases, we find that one party is not represented, they're acting pro se. So next question, please.
Andy, you brought up something important there. Does each party have good knowledge of the child's development and needs? And is there constantly returning to court? Well, they don't need special ed, they don't need therapy, they don't need, and they absolutely do. It's in the record. Pay attention to that.
Right. Simone, go ahead.
Okay, great. So the next one, the individual is requesting or asking if you would be willing to provide the questionnaires that you use to gather information, or if there's a way that they can obtain those, or if you have a link or something like that that they can be purchased, or however that
Yes.
can be
So
shared.
send me an email and I'd be happy to post the questionnaire to you.
Okay, great, thank you. And I'm sure you're going to get a flood of emails. I'm sure there's many people. What you can also do, if you feel comfortable, you can provide it to Rachel and she can also offer it to folks so that your inbox doesn't get inundated.
I can't do that
it's up
because
to you.
the author of the questionnaire gave me the explicit permission to distribute the questionnaire if I did it. And unfortunately, that person's now dead. So I'm locked in.
Understandable. All right. So the next question is, so this person's asking about the flat fee. So they're saying, how can you set a flat fee up front, given that you don't necessarily know or can predict the extent of the interviews that you may need to conduct? You can imagine there's quite a wide variability on how long these take. So that's the question that's being posed.
Yes, really good point. And so, we don't want to violate the antitrust laws of this great nation. And so I'm just going to talk about range of fees. We do sliding fee evaluations, but I'm part of a university program. But private practitioners, they have a range of fee from $10,000 up to $25,000. I've heard even higher for some evaluations, depending upon the number of people evaluated. And so I would urge that when you get a case referred to you, you find out a little bit about the allegations and how many parties you're going to have to evaluate, how many people you're going to have to evaluate, and then talk with colleagues who do this work within your community to find what would a fair fee be.
Okay, so the next question says, you alluded to the disputations issue of custody. There are some who contend that fathers, because of some inequity, often do not stand in good stead regarding decisions in this realm. How veracious is such a position, and is there any data to substantiate whatever stance?
Kelly, go ahead.
All right, you have more of the, what does the data say? The data says when allegations are brought into court of violence, of children being exposed to violence, too often, if someone defends themselves by saying it's false, it's made up, she's not telling the truth, too often the actual bias is against her and the child is put back in danger. Do fathers get fair standing in a profile in a program like this? I think that because this program says ask every question, ask it thoroughly, look for the evidence, it makes the burden of proof on the parent, who should have thought at least a year ahead of time that their ability to parent is going to come under some sort of scrutiny. Presumably, they brought it up. We know that when families separate, right, Andy? When families separate, there is a lot of jostling and suddenly roles change and demands change. And I really wouldn't wish full-time working single parenthood on my worst enemy. It's awful, but it's already been going on. And so what I keep seeing is the reverse of that. I see courts saying, well, he hasn't had a chance. Well, he's had 8, 12, 15 months to figure this out.
Yeah, and boy, the data will emerge in parent-child observation. It's just really remarkable. More questions, Simone.
So the next question is about an estimate on how long these usually take. So like how many hours would you say all in, I guess, you know, from
Really good
start to
question.
finish?
So if you're a fluent writer and you conceptualize well, most psychologists are and do, you can get one of these evaluations done in 25 hours with consultation. And I didn't really impress upon at any point of this particular lecture, it's important to get consultation. If you've got multicultural issues, get consultation. If you've got an allegation that you haven't had any clinical experience with, get consultation. But an evaluation process with consultation will likely take somewhere like 6 to 8 weeks from beginning to end.
And consultation goes beyond that. If one of the children in the family has a chronic illness and you don't know anything about that chronic illness, especially
get consultation. Yeah.
Talk to a pediatric psychologist. Don't figure, oh, I'll understand it. You won't. You won't.
Please, 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 please. Simone, more questions.
So the next question is, do you ever ask to see home videos?
No. And the reason why we don't want to collude with manipulative process. And rarely has a court ordered that an evaluator that I've supervised or an evaluation that I've done, rarely has a court insisted upon my looking at such videos. I know that it's happened though in some cases, which is really unfortunate.
And what's not stated in this question is the fact that we know that when children are abused, the person that they report to is almost always their mother. If they report, it will be to their mother. And a lot of research has been done on when do they then report to a forensic interview. There have been studies when we have physical evidence of physical abuse, evidence of sexual abuse, confessions. When do children report? When do they not report? We have that science. You need to know what we know about children's report. You need to know that children don't report being exposed to violence, that if they've already reported it, then they actually know at a fairly young age that it's already been reported. And then they're more likely to report. Just because they reported to their mother and then reported to you doesn't mean that they're rehearsing something. It means they're acting like a normal child. And if you're not certain about that, or if you don't know forensic interviewing and you don't know what people know about it, go get educated. Don't just take the first thing somebody tells you, because I'm here to tell you there's an awful lot of misinformation.
Yeah. Simone, more questions?
Yes, so the next one I think is asking for a little bit more clarification on the ex parte communication issue. So the question says, I thought I understood they never meet with attorneys ex parte. How now at the end do they do it? So all together, and maybe that person, if they want to clarify the question a little bit more, but if you want to go ahead.
Yeah, so I'm so sorry for any confusion. We do meet with each parent separately for clinical interviews, parent-child observations, and for closing interviews. We do not meet with people between phases of the interview or the evaluation process. We expect them to forward to us any of their concerns in writing.
And then I guess to follow up, because I think the question was specifically related to attorneys. So I assume that at the end of it, just everybody gets the communication all together at the end with the attorneys.
Correct. So even at the end of the process, once we meet with the attorneys, sometimes the attorneys will have follow-up questions, not often, but sometimes. We always make sure that the other lawyer's on the phone when that follow-up questioning occurs.
Yeah, so when the whole thing is done, it's presented to all the attorneys in the room. So there's one meeting and they get all the information at the same time.
Including a guardian ad litem if one exists in the case.
Right. So the next question is, how is it the evaluator's role to encourage settlement? That seems like a potential dual role, not necessarily neutral. How do you feel about the side who refuses? Does that affect your testimony, et cetera?
Really good question. So we're not advocating for a settlement. We're just set up a process to try to encourage settlement as much as possible. You know, and I think based on our, you know, at this point, in all the cases I've been involved with, particularly the most recent cases, you know, only about 2% go to trial. I mean, very few cases go to trial.
I think one of the things that's important to remember is in this process, every single allegation has been investigated to the best of the ability, and the limits of that investigation have been played out. And the findings are set out in terms of what we know about child development. So it isn't just that, well, is there immediate and imminent physical harm threatened to the mom, so we just need to put mom in a box and then let the kid go there? No, you're going to talk about what does the science say about domestic violence and exposure to violence and the fact of the violence, even if he was violent with somebody before this. What does that mean for the parent-child relationship? Well, what that means is there's a higher risk of child abuse. Okay, we know that. Now, what else do we know? What do we know about his parenting? What do we know about his emotion regulation? What do we know about how he prevents himself? And what do we know about what he did when we said, hey, you know, that thing that happened with her or the one before her, that raises concerns for me, and that concern is going in the report.
Particularly if the concern's never been addressed by any treatment.
Right. And when you put it into that framework, the idea is the settlement pressure is completely focused on the child. And I think I would recommend you go to your consultant, look back at your final report before you sign your name and say, did this go through the filter of the child's well-being?
Nice.
Right. I just want to let everybody know that we are at the hour. So if you do need to jump off, the CE link has been posted in the chat. So please go ahead and click on that so you can get your CE. And we just have a couple more questions if you both are willing to hang out. There's like 2 more questions if we can get through. So the next question is, are your questionnaires based on Dr. Greenberg's work?
Yes.
Next question then. Any advice on how to prioritize the important elements of your protocol for psychologists doing evaluations for counties, agencies where time is limited and compensation is a flat fee?
Kelly? Well, actually, I spaced out, so ask that again, Simone, I'm sorry.
You're fine. So any advice on how to prioritize the important elements of your protocol for psychologists doing these evaluations for counties or agencies where time is limited and compensation is a flat fee?
Yeah, I mean, this is a real problem. Go ahead, Kelly. You want to respond or you want me to respond?
What I want to say is this is what you do in your clinic. So you have the most expertise to respond to this.
Yeah, and I have to say that I know that a lot of court-sponsored programs really insist upon work done with alacrity. I would urge that you know, those programs reconsider these very quick evaluations that don't look at all the concerns that the parties have raised, because it just means more litigation. You know, it means that there won't be a kind of any kind of culmination in the parties' concerns. They just will feel like they've been dishonored.
And I think that it also, having seen a lot of these, if you can only do one thing, it would be to go ahead and use that procedure of having people write out their allegations. That's going to be a natural barrier to overspending time. Most of the time. I mean, get somebody hypomanic or manic, it might be different. But let them say clearly and specifically what the allegations are. Let them say what proof they have that it did or didn't happen. Because a lot of quickly done evaluations that get turned into the court are based on one clinical interview that is so astonishingly biased and filtered through the implicit bias and the time constraints. And it's almost as if there's no child. You do not want your name on that.
Yeah, I'm really concerned about that kind of process, frankly. And it happens too much of the time because courts are leery about hiring professional psychologists. So we get these different types of programs where volunteers are conducting evaluations in these cases. They're well-meaning volunteers, but they don't have any background in psychology to speak of.
And then the last question is, what email do we send the request for the questionnaires? Is there going to be an email on your final slides, or?
I think so. Let's just see.
Because then I know that we're going to send the slides out to everybody. So if your email is on there, then
I'm so sorry. I
folks
don't
who-
think I put my email in this slide deck. So let me give you my email. Actually, maybe it's up at the front.
Maybe, I don't think so.
Nope, I took that off. So it's my four initials, GAHB54 at uw.edu. GAHB54 at uw.edu.
Great. Thank you so much. I think that's all the questions that we have. We'll hang out for a little bit so people can grab the CEU link. I see there's some questions about, you know, not seeing it in the chat and stuff, so we'll address those. Thank you both so much. That was great. It was really, I learned a lot. It's not an area that I practice in, so I really enjoyed it. Thank you both for joining us today. We appreciate your time.
Please join us, Simone. We need good people.
Use this procedure in doing civil psychological and personality evaluations. So when there's allegations of harm to adults, unfair firing, I use it all the time. Modified.
Great.
Thank you for coming today, y'all. Bless you all.
Very much.
Thank you so much for joining us. We appreciate your time.
Honor.
Sure.
Thank you both. Thanks, Simone. So everybody should head over to the chat and grab that link. And if you are unable to access any of the CE, if you're having any issues, you can always send me an email. So thanks so much, and we'll see you next week.
Thanks, everyone.
Bye-bye.